I'm Roger Citron, and I have the one administrative position at law school that no one ever wants to leave. I'm the Associate Dean for Research and Scholarship. And one of the things I get to do in that job is to promote and, do what I can. Here, I didn't have to do anything because Sam, the organizer of the conference, he's a turnkey operation. But one of the things I get to do is to be involved in conferences like this one today. And I having moderated sessions, I think every year this conference has been held, one of the things I really urge, like at faculty meetings and so on, I say, this is an area where law and society, by and large, seem to be moving in the right direction. And being involved in this conference, it always cheers me up. And I would say that for those of us in the legal profession, you have to take that where you can find it. The other thing I would say about the conference, and our panel today in particular, is that it's interdisciplinary in the best sense. And you'll get I know you already have a sense of that from the other presentations, and you'll get a sense of that from this panel session. We have 4 speakers today, and we are going to go in alphabetical order down the line here. They are Salomón Chiquiar-Rabinovich, I came close, Duran Dorfman, Adam Samaha, if I got that right, and Max Stearns. Their bios are in the program materials, so I'm going to do what the best moderator does, which is to sit down. Thank you.
Good morning, everybody. It's a pleasure to be here. First of all, I wanted to thank from the bottom of my heart to Professor Levine. I was supposed to speak in last year, and it's incredible because when we speak about disability, I think progressively a lot of the terms have become more and more normalized, but some don't. So seasonal affective disorder, depression, I think mental illness, especially when it comes to the legal profession, runs against stigma. And anyway, with winters like this, I think it's both genetic and the environment, but it's something that combines a lot with what we have. So let's see how this goes. Oop. So that's our agenda. So we're going to understand the business case for neurodiversity. And the essence there in the business case is because when we're in academia, I mean, I'm a prime example. Okay, so I'm a prime example of what happens in academia, but we're going to focus it on when we leave academia, and we definitely have the situation of how is it, and that's the essence really of making a living when you have a disability, particularly in the legal profession. How can we do it? Because when we speak about accommodating somebody with a disability, unless the law firm or the government organization or even in the judiciary, if it's not a two-way street, you'll see from the presentation, it runs into barriers. So we're going to understand the business case about valuing strength by what you can do and not by what is it that you cannot do. We're going to go a little bit over stigma under the lens of development as freedom. That's Nobel laureate Amartya Sen. I found it fascinating how he is an economist and published this book, Development as Freedom, and he really blends into the Jewish view, the vision that when the Jewish people were at Mount Sinai, so at the end, God speaks directly to us, not only in that generation, but in future generations. And he said, Natati lachem et tov v'et hara, bracha uklala, chaim o mavet, ubacharta v'chaim, which means I'm giving you free will. You have good, you have evil. You have a blessing, you have a curse, and ultimately, life is yours, but choose life. And I choose life. My son Chaim is here, Ilana, my wife, and Chaim, who's 11 years old, he inspires me because it says Chaim, right? Okay, so we're going to study a little bit of how stigma and development is freedom join, and what policies do we have that are from research and from the last of science. How is it that we can gauge where not only inclusion, but the essence of belonging? Because people say, well, you include you, we put you in the front of a table. That doesn't mean that you're going to feel that you belong. All right, now, who can tell me here who's in the driver's seat? Okay? This is law school, so I'm going to call on you. Who's in the driver's seat? No, but who's on the wheel? Yeah, can anybody recognize who's in the wheel? Come on, wake up. Yes. Yes, the Queen itself. Now, has anybody here rented a car in London or driven in London? Come on, a show of hands. Right, there you are. Are you originally from the States? Okay. Did it become difficult for you to get accustomed? What was your experience when you went into the car? Speak up. Ah, okay. All right, well, that's exactly what I was looking. Now, if somebody gave you a Jaguar, and here we're close to New York, it disembarks and you go and pick it up, are you gonna find a tough time driving it in New York? Yes or no? Yeah, I'm asking you. Yeah, please, go ahead. Is it gonna be difficult to... Right. Okay, so would anybody in this room tell me by raising your hand, who is left-handed? 1, 2, well, I have 3, that's me. Anybody else? 4? Okay, now who is right-handed? Okay, now today, in the year that we are, okay, in 2026, would anybody here who raised their left hand feel that because of left-handedness, you are devaluated? No, but when I went to school, I was born in 63. By the time I started to write, was probably around 67 when I was 4. And I learned parallel to Spanish. I'm originally from Mexico. I learned Spanish, Yiddish, and Hebrew. Now, anybody who knows about writing and reading in Hebrew, first of all, it doesn't go left to right, it goes right to left. And the problem with Hebrew is that you only can get fluency in Hebrew when you insert the vowels. Now, how could I tell which one was more difficult for me? In Yiddish, you do have vowels, and you can, when you have dyslexia and the decoding of symbols is more difficult, then you have a double whammy, because you have to be able to immediately supplement by recognizing the pattern, the way things are written. So even my father, Oliver Scholem, passed away 11 years ago. I had to daven, to lead prayers from the Omed, and Acharei, Acharai. So, you know, people are desperate, 6:30 in the morning, gotta get to work, and then you have this Mexican Jew who can't tell how to daven properly. All right, so now, look at the questions that we have there. So who fits the mold of typical, and what makes you stand differently? Who defines what's typical, particularly in the workplace, and who's considered typical versus neurodivergent or divergent from the norm? Now, Queen Elizabeth looks very happy. During the war, she was a mechanic. She loved to drive. As a matter of fact, she drove until her late 80s, and she resented very much when people wanted to drive because she loved to drive. And her kids look very happy. But you see in the top, she was 85. The lady was still driving. Would you dare to tell Her Majesty, Your Majesty, you are neurodivergent? She wouldn't like it. And actually, if any of us rented a car, just tomorrow, right now, you want to rent a car to go and see a Broadway musical. And what is the first thing that we do when we sit in a car that's not ours? Or even if it's your spouse, you know, my wife left me the car and says, go to do groceries. You sit down, and the more unfamiliar the environment is, but nobody is going to have a stigma with you moving the rear view mirror or adjusting the sides. So in that, let me make a proposition. Adjusting, do you think it has a more neutral way of sounding than accommodations? Accommodations would be if the lady or the gentleman who rented a car would, sometimes I don't know where the button is, so the lady, because of, or the man who's renting the car, would say, let me help you, okay? And then are they doing an accommodation? Yes, because it comes from their heart. The adjustment is really when you self-adjust or you ask somebody, but there's a big difference between who has the power to accommodate and who is the one that's being accommodated. In England, they use more reasonable adjustments than reasonable accommodations. I think it's not just semantics. So remember I asked you about who's a lefty, right? And who's, so today, and it's very interesting because that comes from The Economist magazine, which is very conservative, very thorough to what they publish. But you can see researchers are questioning really if ADHD should be seen as a disorder or just a different way of being. My proposition is that that is the pathway to valuing strengths versus a disability. Here I am applying, and I think you'll see it from your materials, how in that book, Development as Freedom, Nobel laureate Sen says that disability reshapes the spectrum of capability, and he refers to capability and the opposite as a lack of freedom. Society should define disability as seeing it as what he calls an unfreedom, the lack of freedom, because it deprives really individuals from going. Now, in law firms, the big fear is being different. And people tell you, you know, with dyslexia, it was a miracle that I went through all the reading in law school. Bar exam, it took me 4 times to do it. But once you start billable hours, that's when you crash when you have dyslexia. Because today with AI, it's a miracle what you can do. So let's go over, I have 4 more minutes. What's stigma? What's stigma? And those are the experts, so it's discrediting you. It discredits you socially, okay? It devalues you. I come from Mexico. The Mexican peso devaluated all the time, so it means it was less than the US dollar, less than the sterling pound. And in the end, it's the individual in a group, because I don't feel comfortable when people are just accommodating me. Okay, let's accommodate Salomón because he doesn't know how to write. No, put somebody to write because he's too slow. Or like sometimes the managing partner of a firm told me, so why do I need you if it takes you 5 hours to do what a paralegal in terms of immigration firm can do it right away? So Research shows that despite all of the buzz about inclusion, about diversity, the empirical evidence shows the contrary. And this is from 2024, Harvard Business Review published it. So obviously the non-apparent disabilities, what would you say if a father and mother come to school for an individual, performance? It can be a performance review at a firm. It can be just if you enter with a wheelchair, so your child or you yourself are in the wheelchair, and then somebody says to you, listen, this is very simple. Just walk and take a couple of steps. What's the big deal? You would think that person who's saying that is cruel, but when somebody tells someone with a disability or with a mental illness, how does it affect work? Then they don't say that. They just say, look, you didn't make the minimal 1,800 billable hours. What do I need you for? Okay? So this is a vicious circle about how unemployment goes. And we have dyslexics here, so our strengths are here. Our common challenges is really the decoding of symbols. This is a good cycle, and I encourage you to see it in your materials, where you see that people are scared about disclosing their disability because it's going to already put you outside. So the best thing is to hide it. I suggest that you use, this is from Harvard School of Business, but you can see the cycle. Leadership, for example, in a law firm, they have to make sure that it's not just a brochure. They have very fancy brochure. They put somebody in a wheelchair or somebody with one color or another. It has to be intentional of them going through, especially middle management, etc. The organization has to be mature, and these are the stages. A lot of it has to do with our identity. Identity, just when you're talking about identity, where do you come from? Where does your name come from? Are you proud of your identity? I'm very proud because you have my great-grandfather and my grandfather Levashon. They were both rabbis, people of great, they made an impact. And there was neurodivergence from both sides of my family. Let me just go. I'm a Latin, I was born in Mexico. I was always considered a Jew. When people ask me, what nationality are you? I'm a Jew, and I'm a Zionist, and I'm in good company with Brandeis, Frankfurter, Cardoso. This is one of the things. They gave me an award for DEI, and I said, you know what? Branding somebody, the less are just theoreticals. You have to have allies. That's a very good book that I recommend. Here are some policies, new literature. And I close with, do you think inclusion is a favor? It shouldn't be. And you should read Ludmila Praslova's book, which will enlighten you, The Canary Code. Thank you.
Thank you. That was a great way to start with much information as well as the personal piece. Duran, please.
Hi, everyone. Good morning. My name is Doron Dorfman. I'm a law professor at Seton Hall Law School. I specialize in healthcare law, disability law, employment law, and family law. And I'm here to talk about a recent article of mine called Third-Party Accommodations that was just published in November of 2025 in the Michigan Law Review. I uploaded the article itself, and I also have physical copies because we actually still do that in law school. So if you are interested in that and it's helpful for you for reading, please come to me. So what I want to discuss today is a new type of disability accommodation that I kind of came up with. The legal construct of disability accommodation has been very useful in creating access and ensuring participation of people with disabilities in all areas of life, from education to the labor market. And the rationale behind a reasonable disability accommodation is this idea about removing barriers. It's also how the CRPD, that I know people talked about before, also kind of defines accommodation. However, the scope of what reasonable accommodation actually include has been a big source of confusion and some frustration when translating the law in the books to the law in action. And I want to talk about what I mean by that. So, as you may or may not know, the definition of disability accommodations in the Americans with Disabilities Act is made out of big list, something that you see now on the PowerPoint. It's an open list that covers everything from equipment like an ergonomic chair to services like closed captioning or to modification in policies like a modified schedule. However, how courts traditionally thought about disability accommodation is through this type of a limited relationship between two parties. Basically, we have the first party who is a disabled person who's asking for the accommodation, and the second party is a covered entity under the Americans with Disabilities Act or Section 504 to the Rehabilitation Act, which is a precursor to the ADA. So the second party is an employer or public or private service provider who is covered under those laws. And like you can see in the photo, these are two people, and this is how we use to think, or we are used to think about disability accommodation. I'm also a torts professor, and I teach tort law, and so I named that type of idea about disability accommodation existing only between two parties as the privity paradigm. Privity is basically closeness and how parties are close together. And as I often state in my work, disability law is being enforced in everyday life, not by judges or lawyers or courts. It is enforced by everyday people, lay people. Think about the last time that you looked at a disabled parking spot. Think about the last time you went to a Disney park and saw someone going in line. Or any other type of situation, or someone using a service dog. All those are examples where you encounter disability rights in everyday life, and the people who are actually enforcing those rights are lay people. So the same conception of this idea that disability accommodations only exist between two parties, and that you cannot tell someone outside of those two parties that they need to change their behavior in order to accommodate a disabled person is pretty common. There's a lot of situation where we have third parties who are actually the barriers, their behaviors or the way they act is a barrier for people with disabilities. But a lot of the times people don't think that the ADA actually extends to a situation where you can require a third party to change their behavior. The question is, though, what happened when that situation actually happened and third parties serves as barriers for inclusion or for access? And in other words, does disability law cover accommodations that impose obligations on covered entities on the second parties to tell third parties that they need to change their behavior in order to accommodate a third party? Okay, so that's a big doctrinal question that I'm kind of encountering in this piece. And what I'll do in this lecture, and you'll be happy to know that we already covered some of it, is that first I identify the privity paradigm and its problems, which we kind of like did. I'll talk a little bit more about it in a sec, but we're mostly done. Then I'll explore examples where district courts and circuit courts recognize third-party accommodation nowadays, and situations where third-party accommodations are less recognized. And finally, I'll offer all kinds of tests for courts and decision makers to decide whether a third-party accommodation, an accommodation that requires a third party to change their behavior, is actually reasonable or not. All right, so let's continue a little bit to talk about what are third-party accommodations, or what I called, or how I call them, accommodations beyond the privity. So to hone in on it, again, it comes into play when other people's behavior, acts, or practices directly affect disabled individuals and pose barrier for their access. To remedy this barrier, we need a specific type, a new type of disability accommodation called what I call third-party accommodation. One that prohibits or at least greatly reduces the behavior of a third party or actually requires a third party to do something proactively. Let me give you a few examples so it will be a little bit more concrete. Let's think about situations where we have an employee that has a severe allergic reactions to certain scents and perfumes. When we require other people at the workplace to not wear those scents or perfumes, we are engaging in a third-party accommodation. When we have a neurodivergent or autistic individual, an employee that has issue reading nonverbal cues, we need to require their colleagues to change the way they communicate in the workplace and specifically with that individual, we are requiring a third-party accommodation. When a person who has severe allergy to peanuts is trying to take a plane and to go and to travel, we might require all the other people on the plane not to bring allergen food, meaning peanuts or peanut-related products on board the plane. That will be a third-party accommodation. And third-party accommodations, also have a very important, what I call a relational value to them. Because what they actually do is fundamentally important. Third-party accommodations allow people with disabilities and people with no disabilities to be in the same room together. Without that, they can't even interact at all. And that's why I think they're so fundamental. So let's talk about how third-party accommodations fare in court. And what we can see here is that there's a spectrum, right, from the least recognized type of third-party accommodation to the most recognized type of third-party accommodation. And let's discuss those a little bit. So let's start with the most recognized third-party accommodations. And here I have two examples. One of them are no smoking rules, and the other one is accommodations of food allergies. So in terms of no smoking policies or no smoking rules, meaning prohibiting third parties from smoking in the workplace or in public space, in the early and mid-1990s, when the ADA just started, and before public health laws were enacted to prohibit people from smoking in public, people with respiratory conditions filed lawsuits under the newly enacted ADA, designating such policies, no smoking policies, as an accommodation. And they actually won those cases. Now, you hear me saying that and being a little bit surprised by it, and the reason I am a little bit surprised by it is because if you know anything about the history of the Americans with Disabilities Act, the ADA in the United States, you know about the backlash against the ADA in the first 2 decades of its enactment. And what I think is an interesting point in this paper is to complicate this story. The backlash against the ADA means that the courts were not finding people who came to court disabled enough to use the ADA, and they, as a consequence, did not allow them the accommodations. And here we have a very specific type of success story within this story of defeat, right? And I think the no smoking policies is a really interesting example of that. The second third-party accommodations that fare pretty well in court and in policies, is food allergies. And food allergies, we're talking about 32 million individuals with food allergies. An accommodation for that, a third-party accommodation, is prohibiting allergen food in certain places, but it can also be an active act, meaning we can ask people to wash their hands or wipe all kinds of surfaces, and that is something that is kind of common today. People who have kids know that it is also common under Section 504 plans in the education context. In the middle of the spectrum, we have the issue of masking as an accommodation, which has been an issue during the COVID-19 pandemic and a bit later. I'm talking about situations where we needed an accommodation in the form of an exemption to no masking policies that were enacted in 10 red states across the US in 2021. Prohibiting mask mandates in schools. And this article is the first one to really look at the entire case law on this issue and to map what we call a circuit split. So there are some courts who think of disability accommodations as a reasonable accommodation, and there are 6 courts who disagree with that. I was part of a litigation in Texas, in the E.T. versus Paxton case, where we lost the case. Well, I think you might imagine that Texas is where disability rights and civil rights go to die most of the time, but we did get a dissent, and a very strong dissent, so I consider that a win in my career. Beyond schools, the issue of masking is very important also in healthcare institutions. After the COVID-19 federal emergency state was done in May 2023, a lot of people with disabilities who were immunocompromised went to the doctor, and they could not find a physician where they will actually mask when they come to the clinic itself, whether the physician himself or herself or their staff. The third and least recognized type of third-party accommodation, and I'm going a little quickly because I saw that I'm running out of time, is no fragrance policies for people with multiple chemical sensitivities. Multiple chemical sensitivities is a condition that manifests in severe allergic reactions to fragrances and chemicals within various cosmetic and cleaning products. It is a contentious type of condition, kind of like fibromyalgia or a chronic fatigue syndrome, because it has a very elusive nature, high variation between patients, and no biomarkers to actually recognize that. Third-party accommodation to accommodate people with multiple chemical sensitivities is basically enacting a no-fragrance policy, which is third-party accommodation. Nevertheless, courts have traditionally viewed such policies to inflict undue hardship on employers and places of public accommodations, making them unenforceable and unreasonable. After reading the case law, I claim that discussion is not as nuanced as it needs to be. People with multiple chemical sensitivities do not often require, or most of the time do not require, a complete synthesized, completely scent-free environment. What they require is much more reasonable of a solution. I think that no fragrance policies might not be reasonable in every situation. We can discuss that in the Q&A. But I do want to say that when you travel right across the border to Canada, you see that no fragrance policies are very common in universities, places of a higher education, and in regular schools as well. And this is from University of Toronto, where I recently visited. The last thing I want to do very quickly, because I know I'm running out of time, right? Yeah, is to offer ways of assessing reasonableness of those accommodations. I'm not going to go into details on each one because I ran out of time, but what we need to really think about is the level of infringement on personal freedoms. We need to think of cost-benefit analysis of the accommodation, but in order to do that, we also need to think about the benefits of those accommodations to other people. It's something that needs to factor in the cost-benefit analysis. We need to think about the level of control second parties have over third parties. Think about second parties who run businesses with kids who can't really wear masks, or other people with disabilities that can't really do that as well. We can think about the role of custom and existing norms and recognition of certain impairments. And I want to emphasize that I think that third-party accommodations should apply to all disabilities, even ones that are not lethal. And I'll be happy to talk more about it in the Q&A. Thank you so much.
So as we're setting up here, the CLE code for this session, ZXC 543. Once again, the CLE code for this session, ZXC 543. And I'll say it again at the end of the session.
Hey, thanks everyone for your attendance, and especially to Sam Levine for putting together a terrific conference for the third year in a row. So thanks so much, Sam. Okay, so this is individualization in disability law This is an early stage project. I'm going to go quickly because I want to hear Max and also your questions and any feedback. This is also part of a longer term interest and larger project on individualization under law before the machines. So let's talk a little bit about individualization as a concept. It's got at least two components. So one is informational and the other is participatory. So when people are asking for more individualized treatment, in general, they're asking to be treated as individual human beings rather than as categories. And that includes a demand for more particularized and more complex consideration, both in terms of assessment and in terms of remedies or responses. Also alongside those claims are demands for participation, so that the process by which people make assessments and deliver remedies or responses are more interactive rather than top-down, and more humane, more engaged, more listening, more interaction. So there are examples I can give from law, but also I think this is part of a larger transition and development in legal systems and societies from top-down rule in repressive regimes to a system where we've got an autonomous legal system that can be separated out from partisan loyalties, but then to a system that tries to be more responsive and more immediately responsive to a variety of human needs. So in our law, we've got at least parts of the ADA of 1990. Going back further, the Health, Education, and Welfare Section 504 regulations of 1977, the IDEA, which you heard about earlier today in 1975, and then Supplemental Security Income by 1974, all have some individualized qualities to them, if not fully participatory, then partly informational. So as a graphic representation, and the captions are going to interfere with the bottom part of the slide. So if any part of this talk, you're not quite clear, you're not quite convinced, just assume that whatever is obscured by that captioning, that would have convinced you. Okay, so but up top the idea is deciders, okay, in a hierarchical system that's not very individualized, very categorizing, acting on a set of subjects. And the individualization model is more like this, where we have subjects working with deciders to develop information, insights, knowledge, and solutions alongside those deciders. So to give some examples from law, and now I've got the top title obscured by the Zoom. Fantastic. The technology hates me. By the way, we should be very friendly to the machines nowadays. They're building profiles, you know, AI on us, and so really be polite to them, because later on, that's going to pay some dividends. Okay, so up top in that title slide is to think about some examples of individualization mandates in disability law as it currently stands. I want to note here that I think there was a surge of trying to get individualized law in the late 60s into the 1970s. Some of that got rolled back, but some of it survived in some important landmark legislation. So take the IDEA in education. So it's got a set of listed conditions for a disability, a child with a disability, and that is an individualized determination. People need assessments. And then those impairments, those conditions need to be connected to a need for special education or related services. And alongside that, once someone is identified as a student or child with a disability, then team meetings in order to develop individualized education programs and behavioral intervention plans sometimes in order to, in the words of Andrew F., enable progress appropriate to the child's circumstances. Now that is in no way slanted only toward child benefits, not at all. Part of the individualized consideration is to relieve some burdens on schools. Moving forward to employment, and then one other example from cash grants. Unemployment, we got the ADA's definition of disability, which Doron was referring to a little bit earlier in connection to accommodations. So that includes an impairment that substantially limits such individuals' major life activity. If you've ever heard of the social model of disability, lots of people like to connect that to the ADA, but it is anchored in a very medical model, individualized determination, and then maybe some other responses beyond that. And that's got to substantially limit such individuals' major life activities. Then workplace accommodations, that includes an inquiry into effectiveness. What good would this move do for this particular individual. And there's also an interactive process, not exactly mandated by the statute, but it is encouraged as a way of avoiding damages liability. So many employers will be willing to engage in this process. And that is at least formally understood and pitched as a more horizontal, collaborative process to develop potential solutions. The hardship defense for employers also individualized. You need to think about the actual cost to an actual particular employer. And the direct threat exclusion, the ability to exclude employees as direct threats, needs to be anchored in some particular individual's alleged threat to the workplace. Now, in cash grants, I'll just mention about the definition of disability for eligibility, both in terms of SSDI, the Disability Insurance Program, and SSI, the Supplemental Income Program. So both key into a definition for eligibility that is about inability to engage in substantial gainful activity by reason of certain physical or mental impairments, and then there's a complex process for going through that inquiry. And then plus that, the person needs to have established enough work credits, so worked over enough time, depending on income and some other considerations, in order to qualify for disability insurance, or have to have low enough income and assets in order to qualify for SSI. That's all individualized as an inquiry. Now, there are cross currents in law. We have plenty of categorical requirements, demands in disability rights law. It's not all one way in terms of individualization. So, for example, the IDEA's list of conditions, that's fairly categorical. It's got one potential residual at the end. The EEOC has a list of predictable assessments, right, where if you have this kind of impairment, it should be easy to conclude that that's a disabling condition, and that's fairly categorical in its quality. The ADA's exclusion, ADA has a set of exclusions. Those are categorical. The Access Board in developing architectural guidelines, many of those are very rule-like, very categorical, like the height of the carpet treads and so forth, the width of door frames and so on. That's highly categorical, might be very beneficial to people, but it's not really an individualized inquiry. The SSDI's grid regulations, so SSDI as well as SSI, those grids are simplified ways of evaluating the availability of employment in the economy, for example, connected to various impairments or disabilities. And that was blessed, endorsed in the Heckler against Campbell case, an insufficiently famous case from 1983. The stakes were very high in a case like that. The court effectively suggested a pro-grid canon of statutory construction. So even when statutes indicate that determination should be case by case and individualized, there's a presumption that an agency can nonetheless produce at least presumptive and simplified inquiries to process high volume jobs. Okay, so there are plenty of examples and some cross currents of individualization in current law. That's true. And in addition, we've got some standardized trade-offs, which I wish you could see at the top. But now I'll just bear down on the specifics. So over time, by the 1990s, the trade-offs seemed to get basically settled. So the aspirations, the potential upside for individualizing under law was accuracy. So given a set of goals, being more accurate, more precise, better at hitting those particular goals. But more than that, and importantly, about learning. So not just a set of goals that were prescribed, but goals that could be developed in collaboration with people who had better knowledge or insight. So not a static set of goals that we could be more accurate at hitting, but opening up consideration to what goals should we have. And by doing that, you could anticipate higher levels of legitimacy in these decision-making systems. Like they would be better, they would be more responsive to actual needs and desires, they would be more insightful, they would be open to more considerations, and not only people should be more willing to follow the results, but justifiably so. The attacks, though, also standardized. The criticisms, they started well before the 1970s, but certainly in the 70s, and they carried forward. So that was, this is going to be costly. So it might be great in many ways, but it's going to cost somebody something, and just ignoring those costs isn't going to stop them. Second, the results will be importantly unequal. In a way, individualization is at war with equality. The results The results will be unequal across individuals. That's part of the point. And then there was a sense that maybe everyone's their own law. And how will this all be coordinated? And then finally, the risk of arbitrary discretion and lawlessness. If everything's open for discussion, it's hard to judge, did we get it right on the other end? So I do think individualization is part of a great society. Can we still use that term? It's so out of favor and so old, maybe we could bring it back. So I do think it's part of a great society, but it is going to cost us. That's the idea. And it may be obtuse to larger structural forces. Okay, but what I want to emphasize in my last few minutes here is not those trade-offs, but how the trade-offs get totally unsettled when we study how individualization works in practice. So for one thing, we get simplification. So take IDEA, okay, and IEPs. The evidence I have is that basically from the time that computers could produce drop-down menus, people started using drop-down menus to generate IEPs. That simplification and standardization in the treatment of various requests on the education side, that's the reality for most people when there's any resources at all to address students with disabilities. So we get drop-down menus, we get templates, we get grids, but they're implicit. They're not in the Code of Federal Regulations like the Social Security system, and we get routines, we don't get openness. Second, stratification. So while some people get high-intensity individualization within a certain system, other people do not. And that seems to track advantage, not disadvantage. That is, people with wealth, people with time, people with experts, people with attorneys, they will tend to get lots of attention to their needs, others will not. Okay, and then shutdowns. Some systems just have so little resources. I've heard tell of them saying, we just don't do that here. So I know that might be a good thing because your kid has autism. We don't do that here. So just a shutdown, nobody's getting anything in that system, individualizing or not. And then rationing through delays. Think about the Social Security disability system. That is months at least and maybe years to get a benefit at the other end. And that means a number of people will just lump it. They'll just self-accommodate. They'll DIY without the system support. And then we get opacity to boot. That is, these systems are simplified, stratified, and sometimes shutting down or being interrupted in ways that are hard for us to track. So one system among many is the IDEA system. Within particular schools or particular districts, there's a lot of siloed knowledge and expertise. But for outsiders trying to understand and audit that system, it's very difficult. I know simplification goes on, but it's hard to measure and it's hard to respond to, and we have to take that as part of the system. So instead of subjects and deciders collaborating and high information exchange and being participatory, that interaction becomes grayer. Deciders start to take on a little bit more of that dictatorial or top-down kind of role. And then there's a whole set of subjects who are off-screen who never get into these systems in the first place. And that's part of our reality. So now I just want to close with a suggestion that we can now make some systemic choices more thoughtfully, understanding better what the trade-offs tend to be when we try individualization. So one would be to try to universalization. I'm going to add shun at the end of all of these, okay, just to keep them all on the same plane rhetorically. Okay, so in design, in wealth, in human rights, that sense of disability justice, maybe just ask and tell less about disability, relieve the pressure on individualizing, and like, for example, cut everybody checks for $20,000. Okay, or do something that doesn't require this level of personal inquiry. We could also continue with these individualized efforts, but just be more realistic about accounting for resource constraints, shortcuts, pattern inequalities, and opacity, because that's what we're getting. Now, I don't want to make the second best, like the enemy of the first best, if we really could pump more resources into these systems and do well. But at a certain point, we should be realistic, at least in the short term, that the resources aren't coming, the help isn't coming, and that we may be drifting into a third best instead of a second best world. So a couple other options is templatification. Is that a word, templatification? Well, it is now. And those would be overt grids. That would be like the Social Security disability system writ large. So get our knowledge together, simplify it in a way that would actually be applied in practice. That will moderate the aspirations of individualization, but also its costs. And if we build the right feedback loops, we might get grids that we could actually evaluate and audit that will be better for people than we're doing now, and that we'll understand better going forward. And then finally, and my last point is about automation. So it also is a possible now option to apply generative artificial intelligence and maybe agentic artificial intelligence. That's where the machines actually go and make transactions, as opposed to just writing creative essays. But relying on those types of technologies now is becoming more realistic. And that may be a way of preserving more of the aspirations of individualization than templatification can accomplish, and at lower costs, and on the optimistic side, at scale. Now, AI in its current form, off the shelf, and even the $30 a month versions are not going to do that for us. So that's good for producing the Pope in a puffer coat, and poetry, and short stories, and superficial legal reasoning. That's what the machines could do now. Hallucinations turn out to be not the prime problem. But for higher cost forms of machine analysis, we can do better than I had thought within the last year or two. So if, but only if, we're going to tend to be in a third best world, these are some second best solutions that might not prevent us from doing even better in the future. Thanks for your attention.
Can I ask IT to please just clear the screen, and then we'll hear from Max. Thank you.
Okay. Thank you. First off, it's really a privilege to be here. Fantastic. It's a privilege to be here, but I will confess that when Sam Levine invited me, I thought he goofed. I thought he had made a mistake. I write in that strange space where economic analysis meets constitutional law, and I've never written in disability law. In recent years, I've become exclusively focused on fixing our broken democracy. Sam then reminded me that years ago, we had a conversation about his book, Was Joseph on the Spectrum? And I must have mentioned to him that I have dyslexia, and I realized he had not made a mistake. When I sent Sam my title, Law Professing While Dyslectic, he gently corrected it to be dyslexic, and I explained to him that the less common spelling, dyslectic, sounded better to my ear in adjectival form, and he realized that I too had not made a mistake. First, a disclosure. I've never been formally diagnosed as a dyslectic, but I know I have it. One of my daughters has been formally diagnosed, and of my 3 children, she's the one who reads and learns just like her dad, extremely slowly, word for word, always subvocalizing, in inner voice with no off switch. I've always read terribly slowly. One of my earliest educational memories was in 1st grade. Our class used the SRA reading laboratory system, and students progressed through numbered boxes with laminated folders containing stories and questions, and by the end of the year, nearly everybody in the class had completed several boxes. I struggled to complete the first, and I barely got into the second. In 5th grade, our teacher assigned us a book report, and I remember after going to the library and plucking something off the shelf, asking the teacher whether she meant, as I assume she must have, reviewing a chapter or or did she actually mean the full book? Of course, she meant the full book. In high school, I saw an ad for a speed reading course, and I could get to it from my house by bus. I couldn't afford it, so I asked if I could get an entire class enrolled, would you allow me to attend free? They agreed. I succeeded in recruiting the class, and then I failed the course. Before taking the SAT, I was advised to read the questions before reading the passages. The strategy was completely impossible for me, and although my verbal SAT score was quite wanting, years later I somehow find myself working for Stanley Kaplan as an LSAT tutor. As a child, I thought dyslexia meant flipping numbers and letters. I never did that, and no one suggested testing. I did reasonably well in school until my sophomore year of high school, biology. The course consisted almost exclusively of memorization, and I searched in vain for any organizing structure. And for the first time, my parents were genuinely concerned. And so they met with the teacher. And Mr. Gottlieb explained to my parents I'd probably pass, but not everyone was college material. He suggested I join the Air Force. To this day, I don't understand why he chose that particular branch. Years later, a good friend, a pediatric neurologist, I told this good friend that I'm certain I have dyslexia, and he told me I can't. So I asked why, and he told me that he advises parents of dyslexic children that their children can pursue any career that they want with one exception, becoming a lawyer. I told him to stop. I've now taught law for 34 years. I've taught thousands of students, many with disabilities, blind, deaf, with ADHD, anxiety disorders, panic disorders, and yes, dyslexia. I've seen no correlation between any of these challenges and intelligence or academic ability. I've also encountered another kind of learner, the hyperlexic. One remarkable student told me that as a child, she would go to the library with her mother and return home with a stack of books. An hour or two later, she had read them all, wanting to go back for more. Her mother was genuinely distressed by this. As a 2L, she offered to review my book manuscript, Parliamentary America, The Least Radical Means of Radically Repairing Our Broken Democracy, before it was officially published. I assumed, of course, she's not going to have time, but she persisted. She was my first online reviewer. I later learned that even in law school, she was reading roughly 200 books a year. Her challenge, interestingly enough, was learning to slow down, to read carefully, the way a dyslexic does naturally and by necessity. Dyslexia typically involves subvocalization, a constant inner voice that never shuts off. In my law and economics class, I tell students who struggle with writing to read their prose aloud. If something sounds awkward, it almost certainly is. Dyslexics don't need to read aloud. For most of them, that voice is constant in their heads. Teaching students like her and like me has been one of the great joys of my career. Very different readers with very different strengths. As a child, I had difficulty imagining that people read differently from how I did. My father was a natural speed reader with a photographic memory. I would watch him sit in his chair with a stack of books and flip through them page by page, sometimes several books in one evening. One evening, I was sitting on the sofa and the phone rang. Both my parents taught at our Schulz Sunday School. My father taught Jewish history. The principal, a history professor at Northeastern University, had given a lecture in which he mentioned that Mary Todd once got so angry at her husband that she threw a hot cup of coffee in Abe Lincoln's face. A student was intrigued by the lecture and asked for the source. Dr. Spector was embarrassed because he didn't know it, and so he called my dad. My dad said, "Please wait a moment." He put the receiver down, walked into our library, and he pulled out a single volume, opened up to the specific page, picked up the receiver, and read the relevant passage to Dr. Spector aloud. When my dad passed away in 2013, I wanted to tell that story in the eulogy, but I was concerned I had imagined it. So I searched through the Lincoln collection, and I found it. It's hard to know how I processed any of this as a child. I suspect that I somehow imagined that my dad stored all of the page images in his mind and later returned to read them the right normal way, word by word, just like I did. And I suppose that I further imagined he kept the pages available for reference, such as when Dr. Spector happened to call. Only much later did I realize something that seemed so obvious in adulthood, but impossible to grasp as a child. We can never grasp another person's cognitive experience. And so as children, we assume that others process information the way that we do. And as adults, as professors, realizing that this isn't true is one of the first steps toward empathy toward different kinds of learners. And over the years, I've come to realize the importance of rejecting a common claim, that dyslexia somehow correlates with intelligence. Lists of famous dyslexics are easy to find. Albert Einstein, Winston Churchill, Steve Jobs, Leonardo da Vinci, and the list goes on. But this is misguided. Dyslexics, like any other group, are almost certainly normally distributed across the full range of intellectual ability. But dyslexia sometimes encourages compensating strategies. Those of us who read slowly often develop tools for managing large bodies of information differently. We learn to identify what we truly need to read and what we can safely skip. We develop frameworks, models, charts, and visual or conceptual structures to organize complex materials. In my case, such strategies encouraged analytical frameworks that came to define my scholarship. I integrate tools of economic analysis, especially social choice and game theory, into public law, and recently into the field of studying democracy and its failings. Without realizing it, I compensated for dyslexia by training myself to be hyper-analytic. There are also certain advantages to very slow reading. Early in my teaching career, I challenged a class to find a single-letter typo in a judicial opinion that reversed its meaning. The next day, 2 students came into the class with really wide grins, and they discovered that an opinion described a president as opposite when the court clearly intended apposite. Opposites, opposite. In an earlier edition of the constitutional law textbook that I teach from, the excerpt from Roe versus Wade contained a memorable typo. It describes some as claiming that life begins at the moment of contraception. I explained to the class that something else often does begin at that moment. I'll leave that. Dyslexics often find details that others glide past. For that reason, I've come to see dyslexia less as a disability and more as the basis for developing an alternative cognitive toolkit. One final example. One of my research assistants, an extraordinary student, was effectively illiterate until 4th grade. She has a rare form of dyslexia that causes her to visualize every word she reads. The problem was that many words do not correspond to images. Once teachers and specialists understood the issue, they helped her develop strategies to map abstract concepts onto visual anchors. She went on to become the managing editor of our law review and remains one of the very best research assistants I've ever had in my career. Experiences like these have convinced me of something simple. Law, like many other professions, is a team sport. We need people who read quickly and synthesize large bodies of text. We need people who read slowly and who analyze structure. We need fast writers and we need careful editors. No one person possesses all these skills. I am not hyperlexic. But through dyslexia, I have become hyper-analytic. I often envy fast readers. I quite literally don't understand what it means to read an entire sentence at once, let alone a paragraph or page. And I certainly can't imagine ever reading 200 books a year. But even so, I'm pretty sure that neither my hypolexic student nor I would change places if given the chance. If you know a child or a student who is dyslexic, or my preferred, dyslectic, encourage that person to pursue whatever they wish. The path might take them longer, but along the way, they might see things the rest of us miss. Thank you.
Thank you. I will say that everyone on the panel kept within their time limits, which means I'd be happy to moderate again and again and again with all of you. Any questions from the audience? Because we really had a number of different perspectives. Is there a hand in the back? Yes.
Part question, and I apologize in advance. The first part is, when I was working as a family peer support, I used to be able to tell parents, here are the protections you have at the federal level, here's what you have at the state level, here are the supports you can access at the county level. My first question is, with the dismantling of the Department of Education, I'm assuming that at the moment IEPs are valid and still considered legal documents. My worry is that going further into the administration, because of the impending dismantling of the Department of Education, are such documents at risk? And at the federal protections. My second question is, when preparing to be a peer support, I read that one of the legacies of the No Child Left Behind legislation or initiative was to keep at the federal mandate level the need for programs to be quote-unquote evidence-based. So my second question is, does that preclude or prevent or inhibit innovative practices to be implemented, particularly around children with various disabilities? Thanks.
Yes.
I can start at least. So on the IDEA, under current funding and personnel limits, it's not that the department has been dismantled, and in some ways they're going to build it back up. The initial efforts, DOGE-driven and otherwise, overshot, were miscalibrated for what the administration wants to do. So the department partly got reorganized and partly did get got a partial shutdown effectively. Now on IDEA though, from what I can tell, the money went out the door. So over the summer, the money went out the door to the states. What we should anticipate is very low capacity to do any kind of quality check or assurance of compliance with the legal standards going forward. That wasn't terrific beforehand, though. What we should anticipate now is even greater differences and disparities across states in particular, and then within states as well. That's what we should anticipate. For those who have the resources to get child found, to get an IEP, to have a team, to have an expert, to have an attorney, I think the prospects are still about what they were before. For everyone else, I think we should anticipate greater variance across the country. Some states will pick up the slack in terms of resources, others won't. That was already a problem before. It'll be a bigger problem later. On the evidence-driven programming, that I can say is one part of the department that was largely dismantled. There's almost nobody there now working that system. They had developed really gold standard level handbooks, textbooks, really rules for showing that there was an effect or for questioning effects. And I think that's overall healthy for us to know. I'm not sure how much policy was driving downstream anyway. But I have to say, if we care at all about outcomes, we should find good, sophisticated ways of measuring them and not only rely on universities, my kinds of institutions to do that work, especially for disadvantaged populations. That just won't be enough.
Thank you. Does anyone want to add while we wait for the next question to what Adam just said?
What I can add is that if you compare, I'm doing a PhD now in utilizing the methods of comparative regional studies to compare the profession with the legal profession. First year associates in large firms and first year barristers in England. The semantic difference that I said between an adjustment and an accommodation shows you where the power is. But the bottom line is in both professions, when medical residents hone in the area where they want to specialize in prestigious hospitals, it's the same thing like going into, formally or informally, the practice groups in a law firm, because the one who's the decider excludes people, even if they're buying a table at the disability law, the protection or whatever. I saw that happening I was with Seyfarth Shaw, and they would counsel their clients to accommodate, yet when I was, they say it takes you longer than a paralegal, but yet I figured out the way, for example, in business immigration, that an investor does not need to put the $1 million and create 10 new jobs at the same time. So you could have people who progressively get shares in the corporation, create much more than the 10, and those people got a green card because neither the law or the regulations pushed you to have somebody write a check and create 10 jobs. So that's where, your Yiddish cop or your dyslexic cop works in what here the wonderful co-panelists that I have figure out that you do not, when you're dyslexic, you read between the law, but the medical profession in their beginning and the legal profession in large law firms have, and you won't believe this, 1% or less of voluntary disclosure. And what happens is nobody wants to be different. Nobody wants to challenge those who have the power to take you through the profession, make you great. So that's really where we have to work on. Thank you.
Thank you. We have a question.
So my question is, I think, to several members of the panel. We've talked about how the challenges of the administrative process with obtaining accommodations, how those accommodations can be individual versus universal. My question is, do you see a place in a post-Chevron world where litigators can use that framework to challenge decisions of the school and of the administrative hearings, where there is less deference to those administrators when you're working with accommodations that, in my view, oftentimes live within the ambiguities of the regulation of what is reasonable. Reasonable is, I think, as a good litigator, I would argue, is quite ambiguous and can mean many different things. And so do you see room for arguments that there should be less deference now, not just on sort of a macro level of what an agency is interpreting its statutory authority, but also in the micro sense in these individual hearings?
Let me just inject one thing. Who in this room can tell me who was the first attorney that was given by his employer accommodations? Okay? Anybody here? Anybody daring? How many years? You can go 1,000, 2,000? Well, if you're reading my materials, my example was Moshe Rabbeinu, Moses, the lawgiver. Because when the big client, which was the Kadosh Baruch Hu, the one who created the universe, tells him to go before Pharaoh and really emancipate him, is getting free the Jewish people. What was his response? Ani arel sefatayim, my lips are, I can't speak, I have a speech impediment. And he said, well, who gives sight to the blind, etc. But he comes with an accommodation. He said, your brother Aaron is going to speak with you. So again, after being with Pharaoh, he repeats that in the next parsha because he said, you sent me here, and now the lives of the Jews are worse because they have to get their own straw and their own materials to make the bricks. So he says, I will show you what I'm going to do. But that is a good example of a good employer, a good client who says, I have faith in you, you are the one I choose, and you better take my case.
So I think I take a little bit of a different approach than Professor Samaha on universalization and individualization from my experience. And I want to give an example from my research about masking, for example. I think one of the circuit splits with regard to masking as a disability accommodations comes from the fear that if we make a policy requiring everyone to wear a mask all the time, that would not be considered reasonable and we will never win. That's why when I advised organization during COVID on this issue, I always said, you should take an individualized route as an accommodation. Accommodations, now are individualized. You can get much more than that. So you can think about situations where a professor who is immunocompromised only requires people to come into his office if they mask. Or you can think about a student who is immunocompromised who asks other people to mask around them, right? But we can maybe change the location of that student and the people so the same people who will not be sitting by him and will not wear a mask all the time. Why am I talking about masking? Is because I think universalization of masking is something of accommodations more generally is a very scary concept to I think a lot of courts in a lot of situations. That's just an example. And I think the Luper-Bright decision where it gives much more of discretion to judges to interpret statutory requirements might actually lead to less of granting of accommodations, but they're not individualized. So just an example, but I do think you're, hitting the nail on the head by thinking about those issues.
Real quickly on your deference question, I think even after Chevron being overruled by Loper-Bright, we're going to probably get the same response from the courts. So when the Supreme Court endorsed deference on certain educational decisions, including under the IDEA, they weren't operating under Chevron, so they probably go like immigration law. Like they have these pockets of commitments to deferring within certain statutory regimes. So I think the outcome will still be the same, but give it a shot, right?
Oh, all right. I believe we are at time. Let me read the code. This is the N code, TRE 697. One more time, TRE 697 as the N code. And really, thank you to the panelists. This was a superb session.